Welcome again, everyone, to Legal Aid's webinar on the COVID-19 impact on the immigrant community. Today, we have as our primary speaker, LASA attorney, Jacqueline Perez. Jacqueline, thank you so much for joining us today. I don't know if you would like to give some additional information on your background and experience and work.
Thank you. Thank you for having me, first and foremost. Yes, I'm a staff attorney at the Dallas LASA office of Legal Aid of Northwest Texas. We're not in the same office as Dallas, Maine. I think they're on Main Street. We're on Hervey Street. I'm a UNT College of Law graduate, and I graduated in 2017. So yeah, that's a little bit about me.
Great. No, thank you so much for taking the time to speak to us on this matter. So I'm just going to get started with the main questions that we have. The first one has to do with USCIS. Is USCIS open right now and processing applications?
They are open right now. They have made some changes as to how they're processing applications due to COVID-19. As of April 21st, USCIS is still processing applications, but their offices aren't going to be open until June 4th of 2020. Now, USCIS has advised that all routine in-person services have been suspended, and those are automatically going to be rescheduled once their operations resume. And so this is going to include all of your interviews, your ASD or fingerprint appointments, and naturalization and oath ceremonies. Now, if you fail to receive a notification of a rescheduled appointment, then you should contact USCIS and get more information about rescheduling. Also, all InfoPass appointments, those they must be rescheduled, but USCIS is not going to reschedule those automatically. You're going to be required to do that on your own.
Understood. And what about the stimulus payment? We have heard during the past couple of days that quite a few people have received those either through deposit, direct deposit, or via mail. Do I get the stimulus payment if I do not have a valid Social Security number?
Unfortunately, no. If you do not have a valid Social Security number, you will not qualify for a stimulus payment. And even if you do have a valid Social Security number, there's still a possibility you may not qualify to receive a payment if you're in what's called a mixed status family. So for example, if you are a US citizen or a legal permanent resident, which I refer to them as LPR. So if you hear that means legal permanent resident. So if you're a US citizen or LPR and you have a Social Security number, but on your tax return, your spouse or your child is undocumented, then nobody in that house qualifies for a check. This kind of also applies to people who file with an individual taxpayer identification number, which is also known as an ITIN. They can't receive a stimulus payment unless one of their spouses has a valid Social Security number or at least one spouse served in the military in the prior fiscal year, which would be last year, 2019. Now, those who could or who should qualify for stimulus checks would include people who have DACA, VAWA, U visas, or TPS. They should qualify for the stimulus payment because they have valid Social Security numbers. But again, if they're in a mixed family, the mixed status family, then they will not be receiving anything, unfortunately.
So there's a lot of variables and nuances in relation to the answer to that question. And I just wanted to take this opportunity to communicate to the attendees that a lot of the information that we're going to be giving out during this webinar, we're going to summarize it on a flyer and we're going to be sent out via email to the attendees in case you want to use it for future reference. Very well. For the next question, do I qualify for COVID-related unemployment benefits if I am not a U.S. citizen?
If you're not a U.S. citizen, you may be eligible for unemployment benefits if you're legally residing in the U.S. and you're authorized to work during the base period used to calculate the benefit amount and during the period that you receive benefits. According to 8 CFR 214.1, I2, was that 214.1I, somewhere in there, all U.S. employment-based visas are necessarily tied to active U.S. employment. So this means that if the visa holder is terminated, then he also loses his valid non-immigrant status in the U.S. Now, the regulation does allow for a post-separation of employment, which is like a 60-day grace period to remain in the U.S. and to find a new employer or to arrange to leave the country. So accordingly, unemployment benefits would seemingly only apply to unemployment visa beneficiaries detailed in the regulation, and they're only going to be for that 60-day period.
Okay. And Jacqueline, during this crisis, we have heard that a lot of people, they're struggling financially, and some of them are even struggling to make their rent payments. If I get evicted or if I fail to pay my rent, can this affect in some sort of way my legal status?
I can't think of any type of legal status that would be affected by an eviction or for failure to pay rent. But I could see it maybe affecting your chances of becoming a legal permanent resident, reaching that LPR status, because an eviction or failure to pay rent may be eventually reported to one of the 3 credit bureaus. And so when you apply for LPR status, you're probably going to have to fill out what's called an I-94, Declaration of Self-Sufficiency. And then this form determines whether you're admissible or inadmissible to the U.S. because there's a likelihood that you may or may not become a public charge. So along with that I-944 form, you have to provide all kinds of information about yourself, your resources, your income, your bankruptcy, if you've ever declared bankruptcy, education, and then that's where your credit report also kind of comes into play. And your credit report and the information about your credit score, and you're probably going to be asked to explain that negative credit history. Now, information about an eviction or unpaid rent can show up in your credit report, and so USCIS is going to give you that opportunity to explain it. And so, like, for example, here, if the eviction or unpaid rent occurred because you were unable to go to work or school due to a stay-in-place order, social distancing, and quarantines, closing in your jurisdiction, closing your job or closing your school, then you'll be able to submit a statement that explains that with your application to USCIS, but you are going to have to include evidence of that evidence that where the area where you lived in was ordered to stay in place. You may still have to provide that same type of evidence too if, for example, you find that you need to use public benefits as a result of these stay-in-place orders. Then again, you would have to also show evidence of the order from the county, the state, or the city that you live in. And USCIS in the end will take all of this evidence into consideration in the totality of your circumstances.
And you touch on public benefits and the fear of becoming a public charge. Can I, if I'm not a U.S. citizen, can I be tested for COVID-19? And if I do that, will this make me a public charge?
So the short answer, yes to your first question and no to your second one. And I'll elaborate. So basically, USCIS has stated on their website that they do encourage everyone, even non-citizens with symptoms that resemble coronavirus, to seek medical treatment or preventative services. USCIS has also stated that they will neither consider testing, treatment, preventative care related to COVID-19 as part of public charge inadmissibility determination. Now, one of the things that we need to remember when we're talking about being a public charge is it doesn't apply to all immigrants. It's mainly only going to affect those who seek to obtain legal permanent resident status and those legal permanent residents who stay outside of the U.S. for over 180 days and then they try to re-enter the U.S. At the same time, there's also many immigrant categories who apply for legal permanent resident status that are exempt from the public charge test. For example, these people are going to be your refugees, asylees, T visa holders, U visa holders, and others who don't have to worry about the public charge rule. Now, benefits received by an immigrant's family member, those also will not be considered in the public charge determination. Additionally, Medicaid received by applicants while they were under the age of 21, while they were pregnant or during an emergency, those also are not considered part of the public benefit. USCIS is actually encouraging, again, anyone with symptoms that resemble COVID-19 to please seek the necessary medical treatment or preventative services. Now, the rule does require USCIS to consider receipt of certain cash and non-cash public benefits, but USCIS has clarified that an inapplicable public benefit in relation to COVID-19 testing, treatment, preventative services, that's not going to be treated as a negative factor in the public charge analysis. The list of public benefits considered for this purpose includes most forms of federally funded Medicaid for those who are over 21, but it doesn't include CHIP, Children's Health Insurance Program, state, local, or tribal public health care assistance. That's, any assistance that's not funded by federal Medicaid. Another thing that sometimes people ask is whether unemployment benefits, if they take unemployment benefits, does that make them a public charge? You will most likely not be considered a public charge and inadmissible because unemployment benefits are considered an earned benefit. You earned it through your work, essentially. Another question that comes up is the stimulus check. If I accept the stimulus check, am I considered, if I qualify for the stimulus check and I accept it, am I considered using a public benefit for purposes, of the public charge rule? And again, no, because it's provided in the form of a tax refund that's considered an advanced tax credit. So if anything, I think I would probably recommend that you just don't spend that money and save that check and just return it back to the government next year. But that's what it sounds like to me. But anyway, USCIS has already advised that if a person is subject to the public charge ground of inadmissibility and they live and work in an area where disease prevention methods like social distancing, quarantining, stay-in-place orders made a person's, required that a person's employer, school, or university shut down, then they will be allowed again, like we discussed with the rent and eviction situation. They would basically provide a statement with their application for adjustment of status, explaining how those methods or policies affected their ability to to work and why they had to get on public benefits. And USCIS will consider these in its determination of making a public charge determination. But it would be a good idea, of course, with your application and your declaration to include evidence of that. Include copies of the order that was given by your city, your county, your state, as many orders as you can find stating that.
I see. So having cleared that out, what sort of emergency medical services are available in Texas for non-citizens? Emergency medical services, they're available to all Texans, okay, regardless of whether you are a citizen or not. There is a federal law called the Emergency Medical Treatment and Active Labor Act, EMTALA, and it requires almost all hospitals to provide treatment to all patients who need emergency medical treatment, regardless of whether their patients have health insurance and regardless of their status. The federal law covers all hospitals that have emergency medical departments and that accept Medicare payments from the federal government. So basically, since every hospital in the country has an emergency department and almost all of them accept Medicare payments, this means that the law covers almost every hospital in the country. Now, under EMTALA,
the hospital must perform certain services for individuals who come to their emergency departments. You know, for example, they have to provide an appropriate medical screening exam to determine if they have an emergency medical condition. So this would, right now, what's going on now is this would include individuals who are suspected of having COVID-19. And that's going to be regardless of whether they arrive by ambulance or as a walk-in. I know some people are always concerned, they don't want to take the ambulance, or they do. So it doesn't matter, you're still going to, you know, they're still going to check for your emergency symptoms no matter how you come in. Now, keep in mind that if there's no medical, like emergency medical condition, then at that point, the hospital's obligations under EMTALA, they end. But if there is an emergency medical condition, then at that point, the hospital must treat and stabilize the emergency medical condition within its capability, or transfer the individual to a hospital that has the capability and capacity to stabilize the condition. Also, hospitals that are specialized, that have specialized capabilities with or without an emergency department, may not refuse an appropriate transfer under EMTALA if they have the capacity to treat the transferred individual. And in the cases of individuals suspected with confirmed COVID-19, these hospitals must consider the current guidance of the CDC and public health officials in determining whether they have the capability to provide appropriate isolation required for stabilizing treatment and or to accept the transfers.
Okay. We're going to shift gears a little bit right now and just talk about employer-dependent visas, because I do know that that's a question right now that a lot of our community leaders have. If I have an employer-dependent visa, will I lose my status if my employer files for a bankruptcy, or if I am fired due to the crisis?
Well, according to 20 CFR 655-731, H-1B workers must be paid their regular wages even in what's called a non-productive status. Employers are not required to pay H-1B visa employees if the non-productive status is for reasons unrelated to employment, company-based decisions. Accordingly, employers have to pay H-1B workers in periods of mandatory company-wide furloughs. If they don't, this employer could be subject to fines, back wage obligations, and possible debarment from the Department of Labor's temporary and permanent immigration programs. And so what this means is it's going to prohibit USCIS from approving their immigrant and non-immigrant petitions filed by the employer or by the company. Now, unless otherwise prohibited by state law or the paid sick provisions of the new Families First Coronavirus Response Act, employers are allowed to require furloughed H-1B workers to use their accrued paid time off. So notwithstanding if the furlough is prolonged, employers are required to continue paying their H-1B employees their regular wages throughout the furlough period, and the employer's obligation to pay for furlough time ends in the case of a bona fide termination of H-1B employment.
I understand. And what about changes of the workplace? Do I need to contact USCIS if I have an employer-dependent visa and I am now working from home or teleworking?
Yes. According to a March 20th, 2020 Department of Labor communication, teleworking is allowed if the H-1B employee is working within the same area of intended employment or metropolitan statistical area, MSA for short, that's included in the worker's labor condition application. Now, make note that the law provides that employers must afford their H-1B workers with the working conditions that are on the same basis and in accordance with the same criteria that it affords its U.S. worker employees. So what that means is that if an employer allows U.S. workers the option to work from home, then the employer must also afford this option to his H-1B employees. Now, in terms of notice, USCIS guidance only requires an amended H-1B petition if the employer is required to file a new LCA. In the March 20th communication, the Department of Labor confirmed that they don't need to file a new one if there's no changes in the terms and conditions of the H-1B employment.
Okay. And our last question related to employment visas. Does my employer need to provide me with benefits related to emergency paid sick leave or FMLA if I am not a U.S. citizen?
Well, even if you are a U.S. citizen, you may not be covered under the Families First Coronavirus Response Act for the paid leave provisions. This is going to depend on the company that you work for and whether that company qualifies for exemptions and for exemptions from the paid leave provisions.
Okay. Now, shifting gears now towards more recent news. We know that President Trump signed an executive order last week related to immigration. How does this new executive order, how could it affect the immigrant communities in the United States?
Okay, well, Trump's new order, it only suspends applications of green cards for immigrants who are currently outside of the U.S. and do not already have a valid immigrant visa. So I'd say if you're here, don't leave. But it also stops U.S. citizens from being able to bring their parents and adult children into the U.S. as residents. But remember, if the family members of the U.S. citizens can apply to adjust their status in the U.S., then those people will not be affected. Spouses and children under the age of 21 of U.S. citizens have been exempted from this order, and so they're still going to be allowed to apply and get visas once the Department of State is back up and running and offering visa services again. I'd say one of the hardest hit groups it would be for family members of LPRs. There's no exception for their spouses and there's no exception for their children. This means that LPRs would not be able to bring any of their family members into the US. And of course, with all mandates and all rules, there's exceptions. And so this order, it's not going to apply to immigrants who seek to come in through the medical field to assist with the efforts in fighting and alleviating the effects of the COVID-19 outbreak. This exception also applies to people entering on investor visas. Any immigrants that would be able to help U.S. law enforcement objectives are also covered under the exception, and members of the U.S. Armed Forces or their spouses and children. And there's other categories of people, but those are the really ones that really stand out. Now, this order is going to be in place for 60 days. And then during this time, it's going to be evaluated by the Secretary of Homeland Security, the Secretary of State, and the Labor Secretary. And they will recommend to the president whether to, continue the order or modify it or stop it altogether.
Okay, thank you for that. And we're going to leave this time at the end to answer some of the questions that the community may have, but haven't seen no questions in the chat. I was just going to leave this open. Do you have any additional resources that immigrants can use in order to get more information?
Well, I'm going to use this moment to plug our Dallas LAHSA office, if I may. So the Dallas LAHSA office of Legal Aid of Northwest Texas actually does help immigrants who are eligible for visas under VAWA, T visa, and U visa. So to be eligible for a VAWA visa, you would have to be, the survivor of domestic violence. You were married to a U.S. citizen or LPR spouse who's abusive. For a U visa, you would have to be a victim of a crime, and you cooperated with the investigation or are currently cooperating with the investigation of said crime. T visas would be somebody who has been as a survivor of trafficking, whether it's human trafficking or it's sex trafficking. You could also be eligible for a T visa that way. And so those are the services that we do offer for immigrants, along with a plethora of other services as well. They can definitely give me a call. My phone number is 214-243-2525. My extension is 1770. They can also send me an email. My email is perezj@landwt.org. It's Perez, Perez, j@landwt, LANWT.org.
Great. So, all right, I think that is all the time that we have for today. I just wanted to remind everyone again that CRP at Legal Aid of Northwest Texas is going to be distributing a flyer to all the attendees summarizing the information discussed in the webinar. So if you would like to receive this information, please reach out via email. But yeah, thank you so much for attending. And Jacqueline, thank you so much for taking the time to talk to us. Before we leave, I just wanted to remind folks that LANWT is going to continue hosting similar webinars in the upcoming weeks. So just stay tuned for emails or Facebook posts highlighting the details and all the details for future events. So thank you everyone so much. Thank you, Jacqueline. And I think that's it for today.
For having me.
Right. Thank you. Goodbye, everyone.